Attorney Darrell Oneal and the special guest host, Attorney Jerome Payne. Live TV to Roku, Fire TV, and Apple TV. Download the SVP TV app right now. Check us out every Tuesday on Comcast Cable, Channel 17.
Welcome to Talking Law with Darrell Oneal. I'm your host. I got my main man with me, Jerome.
What's up, Darrell?
Hey, another day in the neighborhood.
Absolutely.
Man, we got to tell everybody, if you want to see this, you can see this live with Fire Stick. You can do Roku, or you can do Apple TV. You know, we also, there's an app, SVP.
Oh, I do know that.
Yeah, there's an app. So you can also download the SVP app, and you can download it, and then you can look at it at any time, anywhere you want to.
Gotcha.
So we need to say welcome to Little Rock.
Okay.
Welcome to West Memphis. Welcome to Memphis, Shelby County. Welcome to Mississippi, and welcome to the great state of Missouri.
All right.
What's up, Mom? How you doing?
There.
Trying to figure out how to protect yourself with this debt.
An absolutely phenomenal show last week, Darrell, because we led right in from a very pressing type scenario where someone had gotten themselves into a situation where they just flat out says that I don't care how much the debt is, I can't pay it.
Yeah.
And so many times people have been there. So what do you do when you get there, when you get somewhere when you can't pay it?
Yeah, I mean, and here's the funny part, we started that off from somebody that was concerned about defamation and getting a judgment against.
Exactly.
And that was really based off of
Cardi B
getting a judgment against somebody for defamation.
$4 million.
Yeah.
There. 1, 2, 3, 4. The person said, okay, hey, I can't pay it.
Yeah, I mean, what are you going to do?
So where do you go when you can't pay something?
Yeah, I mean, that is always the line in the elephant in the room, as my daughter always says.
No question.
That if you have a debt and you can't pay, what do you do?
But there, one thing about this particular relief valve, so to speak, it's been around a long time. From ancient times, it was there because we live in a country where we believe in second chances, we believe in fresh starts. And so this is an avenue for a person to have a fresh start, because one thing, we love innovation, we love people starting businesses, we love people taking a chance, and we don't want anything to hinder that. So if you should happen to get in a situation where you can't pay, that's not the end of the story. The rest of the story is what we're going to talk about tonight.
Yeah, I like that, Jerome, because it's definitely not the end of the story.
Not the end.
And you have people, man, that do all kinds of bad things because they gotten in a bad situation.
Right.
Debt or debt is not the final answer.
Darrell, I love that sometimes you see that sign says, I got 99 problems, but women ain't one. or men are not that, or whatever it is. And so you might have 99 problems, but being stripped and struck by debt, there is an out.
Yeah, and so let's talk about a couple of these things.
Okay.
So one of my father's old sayings was, you can get a judgment against somebody, right? And it can be $1 gazillion.
That's the easiest thing to do.
Yeah, but if they ain't got a pot to piss in or the window to throw it out.
And Darrell, it's funny that you say that, because when people come to one lawyer, they believe that if I can just get the judgment, then I'm home free. But that's just the beginning.
Yeah.
Because then you got to have another lawyer to collect on the judgment. And that seems like it's not, because going to court, getting the judgment is probably the easiest step in this whole process, because then someone has to discover, first of all, are there any assets to collect the judgment? So many times people just go on and say, hey, you know what? I'm not going to be spending good money after bad trying to collect on the debt. where there's nothing to collect.
That's, and you hit it on the head, because that's really what ends up happening, Jerome. And we see this so often, where somebody gets a judgment against somebody, and then it's a hollow judgment, because they don't know, they can't collect, they don't know how to collect. Person doesn't have a job.
That's right.
Or if they have a job, their person they work for, it's not registered. I mean, there's just some way, or they paying them under the table, or paying. Look, and I'm not advocating that you need to pay somebody under the table.
No, absolutely not.
But they're paying them other ways where they're not considered W-2s or 1099 individuals.
Absolutely. And then there are people say, you know what? I'll quit this job before I let somebody come in and start garnishing my check. You know what? I'll just do it again.
And that's what that's what people do.
Yes.
I mean, what ends up happening is, and we see that too often, somebody's job hunting or job jumping. Somebody you say, well, they used to work at this.
That's right.
And you check, and they used to work there, but they don't work there no more.
That's right.
The person they work for don't even know where they're working at anymore.
Oh, Darrell, but you just opened up something very important for an employer or someone who used to have funds that belongs to a person who's no longer employed.
Right.
They can't just sit on their laurels and allow a garnishment or a levy or something to arrive and they do nothing, because that's when you get a sour faces against you as an employer or a business person, and you could wind up being responsible for that debt. That's more like something for down your line for your clients there.
It is, and I've had a couple clients that they have responded to because when you get the sour faces. What the collector is trying to do, or the creditor is trying to say is, hey, this person owes me money.
Right.
We understand that they work for you.
Right.
Now,
and we served you.
Yeah.
And you didn't respond.
You have been served.
That's right.
And because you've been served, you must respond. Is put a zero in there and they don't work there, or that person doesn't work, and then send it back to the court.
That's all you got to do. The last day this person worked with me for me was this day. Send it back in the court and you're done.
Yeah.
But to just put it in your desk drawer and leave it, and then there are sometimes people are very creative. The person who the judgment is against might be the one who's at the desk who received, and you think they're going to turn it.
That's what sometimes defendants use against plaintiffs.
Yes.
And, so if you served my business and it was signed for by the secretary is not considered a registered agent.
Absolutely.
And not a person that can accept service on your behalf. So there's an argument that the secretary cannot bind the corporation.
Absolutely.
So if they took it and stuck it in their drawer,
right.
Because if you send it to my registered agent and my registered agent sticks it in their drawer, and that's a problem.
That's one thing.
But if you send it to me, because what people don't know, and you can serve a corporation by certified mail.
Mm-hmm, mm-hmm.
But you got to make sure that whoever's receiving that certified mail is the person who's responsible to receive it.
Or the person is in a certain position in the company, like the president, maybe vice. You could probably get away with serving one of them.
Yeah, I think the statute, or the way I understand it, says managing officers or managing directors, managing officers.
I agree. Yeah. But then there may in fact, you talked about it last week about someone trying to get service, and they served someone in the corporate chain, but it was not the right person.
You can't serve Joe Smuck.
That's right.
And like, for instance, if you were suing McDonald's, right? And
that's a good point there.
McDonald's is a franchise.
That's right.
Every McDonald's is not connected to each other.
That's right.
I mean, only the over the top is connected. So if you have an accident at McDonald's, you can't sue corporate. So now there's a potential that you could sue corporate McDonald's if you can establish, because sometimes McDonald's own the property.
And it depends on what the suit is about.
What the suit is about.
Because it could be that it's the what they call the golden arch falls on you. Mm-hmm. Now that's more than likely that slip and fall in the McDonald's. That's the local franchisor, the franchisee probably, who's responsible in it.
Yeah, and here's what I think on regards to if something with like the arches, right?
Right.
The issue really is not, because I think if McDonald's, because McDonald's actually leases on some of these franchisees.
I agree.
They lease the property, lease everything to them.
Okay.
So McDonald's is the landowner.
Okay.
And the property owner.
Okay.
And the franchisees is written that space and those types of things.
Okay.
So there's an argument that McDonald's would have responsible for the sign.
And you know, that's a great argument, and that's an argument that you as a lawyer don't want to be caught up in
Right.
by suing the wrong party, and that's why you just sue everybody down the line.
You know, they used to call it. You know, they used to say that when plaintiffs, they used to hate it. Plaintiffs' lawyer would do a shotgun.
That's exactly
approach. They called it a shotgun approach. They just sued everybody.
Everybody.
And then people would say, you sued the wrong person.
That's right.
And my rule had always been, if I sued you, the wrong person, get yourself out.
Just file a motion to dismiss
Get yourself out.
because I'm not a party to this particular action. I got nothing to do with the Golden Arch. I got nothing to do with this, or that's not my employee. But you just cannot. Again, people have got to know there that a lawsuit is a serious matter that requires action within a certain time period. And general session is usually within 10 days when you receive, but it may be longer in circuit or chancery.
Yeah, I don't know what the number is, but I mean, but here's how good that is. It tells you.
Right.
I mean, you read the
You don't have
document.
to guess.
The document tells you you need to respond within a certain period of time.
You're absolutely right.
You know, if
Boo Boo ought to be able to see that.
if reading is not fun, you're not the business owner if you can't read.
You're absolutely right.
But usually, it tells you, you got certain, you need to do something within the X amount.
You are absolutely
it tells
right.
you
And
if it's not you or it's not your employer.
You're absolutely right.
Think about this. You send me a garnishment for Jerome Payne. Jerome ain't worked for me, ain't never worked for me. My draw.
Put it on the desk. Well,
I have-
well, Darrell, you're busy. You're a busy business person. You're
Yeah.
trying to earn a living. You don't have time to be answering no that dumb stuff from
For somebody that don't make no.
It ain't work for me.
It ain't never worked for me. I don't even know who this person is. Well, here's what the law says. You got served with now. Just assume the death.
You helped Jerome out.
So now I am paying for Jerome. I don't even like Jerome.
Don't know.
I don't know him. I don't like him. I ain't never heard of him.
Exactly right. And you're responsible for that debt.
You responsible.
And look, Jerome might send you a thank you card.
Jerome gonna send you a Christmas card. Jerome gonna say, "Hey man, I appreciate that.
I so appreciate that,
I
man.
don't know who you are."
I didn't know how I was gonna pay for that debt.
Yeah.
Look, I ain't gotta pay for this debt.
Yeah.
But
Thank you, Jesus.
But then
Yeah.
we're laughing, and it's really
Well,
serious.
it is serious, and we are laughing about it. But the point of the matter is, why are we laughing? Because if you put yourself in that position, you should be laughing. That's why we laughing, because it's a simple remedy.
But
respond.
The other thing is too, is I had a client come to me one day this week with a garnishment. Okay, he said that his employer just gave it to him the day before, and so he's coming to me the day after. Okay, so, and they've told him, we're getting ready to hit your check for $462.
Right.
I said, hold it. That's not how this works. It plainly says on the garnishment document, in paragraph A, it tells you, you have been cited as the employer, and within 10 days, you must respond to this. But then in paragraph A that you receive it, you are to notify the employee to give the employee a chance to do what they can do to protect themselves. If you fail to do that, then the whole thing goes out the window. So I said, hold it. I pick up the phone and I call the employer. And she was nice and I was nice to say, okay, hi, I'm Attorney Jerome Payne, and Mr. Jones is sitting in my office. And it says that you just gave him this garnishment today, and you're going to start garnishing his check on today. I said, if you just take a moment and you read paragraph A, you see what your responsibility is. But in paragraph B, it tells you in the same day you're supposed to notify the employee rather. She said, well, I just got it. Oh, that's well and good. But your obligation is to respond within the 10 days.
Yeah,
You don't have to start taking this man's money immediately.
I ain't ready, 'cause I need to be able to quit.
That's exactly right.
I need some time.
And she was very amenable to me, trying to, and rather than getting defensive, and because you have to be very careful.
Yeah.
Because
you all in my business? You trying to tell me how to run my business?
And Tennessee is an at-will state. Which means what?
They can fire him.
He can be fired for any reason. Even your lawyer called me and talked to me so bad until get your stuff.
You know what? And ain't nothing illegal. We always talk about it. Ain't nothing illegal about that when your lawyer causes you to get fired.
That's exactly right. And so she said, you know what? She said, I've never read it. I've never read either one of these sections before, and I appreciate you educating me about it. And so that turned out to be very good. But do not look at it, because all they want to do is get the honest off of them. I don't care if I take every dime the employee got, but I'm not going to be responsible for his death. And that's just not how it works.
Nah, and I think look, and that's how we're making fun and making light of some of this stuff. But, there's two responsibilities, Once somebody gets a judgment, then in their mind, they're entitled to collect.
Yeah, right.
And with all due respect, any means possible.
Right.
So, they can actually file a lien and place it on your house.
No question.
They can file a lien and place it on your car.
That's right.
No,
bring the tow truck with them
and get your car
at the appropriate time. At the appropriate time. They just can't do it the day they get the judgment.
No.
To walk out the courtroom and go do that.
No.
Because there's a follow-up thing. Then you have to get a writ of execution, which then gives you the authority to start trying to collect.
Yeah, leaning and levying.
That's exactly right.
Yeah, and garnishing, leaning, levying, and garnishing.
That's exactly right. Yeah.
Smart collectors know this.
That's right.
And then, you got great collectors who, do the judgment and then they follow through and to get your stuff.
That's right.
I tell people about my guy Joe.
We had Joe on the show one time.
Man, Joe, my guy, man. Yeah. Joe was on the show. Joe talked trash, man. We had Joe on the show. Joe said, "Hey, man,
I'm coming.
I'm coming to take the chairs. I'm taking the chairs out your house."
Now, another thing too, Darrell, is that the law requires that you not disturb the peace.
Yeah, you can't disturb the peace
when you are doing collections. So debtors or people who owe money don't voluntarily release anything.
Yeah.
When he says, "Give me the keys," man, I ain't giving you my keys.
Yeah.
I'm going to do this. So I said, well, you just have to do what you got to do, but I'm not giving you my keys.
And you can stop. Now you ain't gonna stop it forever, but you can stop it today.
That's right.
You call 911 and that stops it today, because that you can't use the police.
Well, when they arrive, they're going to come, but they're going to say it's a civil matter.
Right. And you can't.
And that'll slow the road for the minute.
Stop.
They can't by telling you to give them the key. Well, let me put it like this: they shouldn't.
They're not supposed to
get involved in it at all.
Yeah, they're supposed to stay out of it.
But an officer who may or may not, they may not understand and tell someone to give the keys up. But that's not how it's done. They're supposed to stay neutral in that situation.
Yeah, you don't get to use your badge.
That's exactly right.
This is a civil matter. Why don't y'all just figure it out? Why don't you just, if you ain't helping, get in your car and go home?
That's exactly right.
But no, but the police is supposed to, if they say it's a civil matter, and Jerome, here's what I think is supposed to happen. If the police is called in a collection,
and I think you should call them.
Yeah, I think if the police is called in a collection matter for levying or taking or repossession or whatever that case is, I think that possession stops immediately. And here's the reason why. Once the police is called, there's an argument that they are being used to assist.
I agree
in these collection efforts.
I agree. I absolutely agree that the fact that the police have been called and they arrive on the scene, it automatically puts more leverage on the collector
Yeah.
than it does the person who's
Yeah.
been. And so what should happen is the officer arrives and says, look, you need to go downtown and try to get this resolved.
Right.
We're not involved in it, and we're not going to allow you to disturb the peace.
Right.
Because
that's what the issue is.
That's exactly right.
Because calling the police means that the peace has been disturbed.
That's exactly
That's what it. I think as a matter of law, that's what it means. That don't mean you resolved your issue.
No.
That don't mean it's gone.
But you good
today.
But you drive again for
just today. You gonna get to drive one more day.
You can go to church one more time in your ride, or go to the grocery store. But be on notice that the tow truck probably is going to be following
that bug gonna be following you like a
to Kroger's parking lot just as soon as you dot grocery.
Ain't gonna be no car.
It's gonna be gone.
Yeah. And that's how they do it. Because you call and say, if you run out and pull your gun out on them or something like that, that's an issue about disturbing the peace.
Don't do
well, you shouldn't do
that.
But I'm just saying, if that happens,
right.
or you run out with a bat,
right.
or you run out with
don't do that either.
Again, that is an issue of a disturbance.
That's right.
Truck person is supposed to get in your car and gone.
And then you get on the phone and you call your lawyer.
Yeah.
And look, there are so many lawyers advertisement there until it's just sickening, just one after the other. And you don't necessarily have to hire that lawyer,
right.
but at least that lawyer would tell you, this is what needs to happen. And so you'll start having some direction on where to go.
Yeah, because I think, and it's funny you say that, Jerome, because that somebody can come to your house and actually take your car.
Right.
That's the nicest thing. The worst thing is you in New York and you drove to New York and a tow truck followed your bus.
That's true.
And you eating it. You come outside, your car is up on a lift. Your car ain't even on a lift. It's gone.
That's exactly right.
It's gone. Now you got to figure out how you get back to New York.
That is exactly right.
That's the worst time.
That's exactly right, Darrell.
And normally, it's not when they are at your house that's a problem. It's when they take your car and your other places.
And then they have no right to cut the lock off a fence, go into a garage, to move another car out of the way so they can get that car, drag your car out of a space, because any damage that occurs during this repossession. Now, let's make this clear there. There is an absolute right, and it may be an absolute right, for a creditor to call in a loan that has defaulted. That's the first step. I think that's right.
I think that's right.
And so then I can use whatever means I believe are necessary in order to regain my collateral.
I think so.
But I must do it without damaging your property,
correct.
without entering into a space where I'm not allowed to be. Yeah, that's what I mean.
Yeah.
Okay. And so should you have some damage occurring due to a repossession or something like that, you can recover for that.
Yeah, but here's where always the issue is. Proving that issue, the damage.
Well,
but if they come on your property and cut a lock, absolutely illegal.
no question.
And I think that's a problem.
I think you're absolutely
And
correct.
if you call the police and present proof that they cut the lock, I think they're going to have some problems.
I think you're absolutely correct.
And there's an argument, because my understanding is if they're going to repossess a vehicle, they're supposed to notify the police of that vehicle,
you are absolutely
location,
correct
and
there.
VIN number and all that. So when you call in about my vehicle been stolen, they say, nah, your vehicle was repossessed.
That's right. And that's what I tell people too. When they call me and said, well, let them tell you that's what happened, because your car could have actually been stolen.
It could have been.
And so, and you're right. Should they not do the right way by notifying the police? That's also a possibility that you could recover for that, or maybe even mitigate the damages somewhat.
Yeah, and again, look, these people that do repossessions and things of that, if there is a possibility that you can work it out, and you really probably should have done that before they got a judgment on you, but if you got a judgment on you and it's not been worked out, then what you need to do is you need to work it out on the back end.
Well, there are two, and that's good. I like that. Even at that late moment, you're late, you failed to do it, you didn't work it out earlier. Excuse me. And many times people would have their checkbooks with them and go on and write a check or something, or go ahead and pay the driver, because the tow truck driver does not get paid unless they come back with the vehicle. And so his motivation is to get the vehicle.
Right.
But even when it's repo, you still got to pay the repo fee.
You do.
So you might be able to give the driver $200 or $300 in order to not repo your vehicle at that particular time.
Not normally.
Well,
maybe.
Because that's all he's going to earn.
I'm not really sure that's legitimate.
Well, why not?
Well, I guess it would be.
Why not?
Hey man, leave me alone today.
I need to do X, Y, Z, and I'm gonna be going to my lawyer tomorrow. But and I've seen it happen even with evictions there, that you can have a private process server to come to the door and say, hey man, I'm really supposed to be doing X, Y, and Z, but you need to get on your game and do something. So I'm gonna give you till late this afternoon. I got several other ones that I'm doing. And I'm gonna come back here later this afternoon. Make sure you get something done.
Yeah.
Because look, around Christmas time, around the holiday or something, you got a bunch of children and stuff, and all your stuff gonna be outside.
Yeah.
You might get a process server with a heart or something. So it's never too late. And okay, even in a business, many times when they come to take your cash drawer, they come to remove.
They'll take your cash.
You're a doctor and you got an X-ray machine or something, and then they come and load that up. But you got several X-rays scheduled for the day. Write a check for $1,000 or so, and buy yourself 2 or 3 weeks before they come back. Barton does it all the time.
Yeah, now Barton, I know. you don't want me to take your stuff? I tell you what.
That's right.
You need to give me some loot right now, and we'll sit it here.
And it comes off the debt. It probably doesn't make much difference if it's a huge amount, but at least you get a chance to continue to earn some money before you lose the piece of equipment.
It's my livelihood. You take my X-ray machine, and I'm gonna make
exactly
$400 an X-ray, and I got 10 of them. That's $4,000.
That's exactly right.
All I owe you is 2. I need this.
That's exactly right.
So tell me what I owe you, and I may write you the check.
That's exactly right.
And that's just Now I know that's how Joe does.
I know that.
And
still, that's the way it should happen. But to be out there shouting, cursing, and I'm gonna do that, I'm gonna kill you, and you're gonna get killed, and all that's a no-no.
Yeah.
Especially in today's time, that could probably be an aggravated assault, depending on how aggressive you are.
Yeah.
You could wind up with a charge behind that. So the best thing in the world is to go on and try to get out of that situation for that day, and then take some other action to get this matter resolved. It does not go away.
No, it's not going
without the legal process going through its.
The funny thing though, Jerome, and we've talked this in many shows, and we're not going to hit it today right now, but you get your vehicle back immediately. You file bankruptcy.
Well, not immediately.
Relatively soon.
Relatively soon.
Relatively soon. And any payment that you've made, you get back relatively soon.
That's exactly right. Yeah. And that's excellent, because there's a new ruling concerning the 362 automatic stay. It came out of the title of the case is Fulton versus Chicago. Well, Chicago was pulling cars just for tickets and stuff. The only way to get your car back, you had to pay all your tickets off and then get the vehicle
parking
back.
wars. That's the show Parking Wars.
All of that. And so what happened was the Supreme Court came in and
U.S.?
Yes, the Supreme Court.
Oh, wow.
They came somewhat in Chicago's favor, that to just keep a vehicle that's been repossessed was not a violation of the automatic stay. But it's if you do anything else, that's what becomes a violation. In other words, you try and collect money
after you got
because there's two different two different areas for.
Well, that hurts them then, because you pull the vehicle, but you can't get no money off it.
You're just holding it, and so that was a thing. They would try to. We used to be able, like you said, if you filed bankruptcy immediately. Go down and pick your vehicle up. But what that did was they gave them some reprieve so they can hold it now and not be a violation.
Yeah, but they can't
demand money,
and they can't increase your penalty.
That's
because they're holding a vehicle.
That is exactly right.
Well, that hurts them.
Well,
now
it does,
because now you got a vehicle that you can't get any advantage of.
It does.
So they're not going to pull those vehicles. That was a win for the creditors.
It certainly was
for the debtors rather.
And Judge Sotomayor gave us our out. It's in another section. It's in 545 where you file a complaint to compel turnover. But that's a long, drawn-out process.
You got to go through that.
Yeah, you see.
You got to get a date from the court. You got to file a motion, get a date, get it set in, and then the other side's got to get the chance to respond.
Absolutely.
Yeah.
That you do not get caught up in a situation where you should have turned the vehicle back over and you didn't do it.
Yeah, those are normally not the repo companies because it's the people they work for.
Exactly.
The repo companies, they don't put the vehicle wherever they told them to put it at.
But they have some liability too.
Yeah.
Remember?
Yeah.
There's something in the law saying that if you rely on attorneys' advice, many times that's enough to cover you.
Right.
But if it's so outrageous, your behavior
and hopefully ain't no attorney giving you no outrageous advice.
Well, sometimes somebody might say something off the hand. That's why you and I have to be careful.
Yeah, you better not go up there and start standing on nobody's table and acting like you lost your mind.
That's exactly right.
I mean, and I'm never going to tell you anything like that.
I'm not going to ever. do that
I mean, you have rights, but you still got to be a human.
That's right.
You got to act.
To hide a piece of collateral, you can't just hide I'm hiding it.
Yeah. Don't tell nobody. And if you do, don't tell nobody because it's illegal. Now you got somebody else aiding the bed. Anyway, man,
they don't never get it because I got it hid in my garage.
No, my boy Pookie's at Pookie House.
Right.
Yeah. So,
all that old street stuff.
Yeah,
we're trying to get you away from that get into the legal process.
Yeah.
But they acquitted my man for shooting in Breonna Taylor's house.
Yeah, I heard that.
All 3 charges.
Yeah,
that's ridiculous, ain't it?
Well, there's more to it than that. We'll have to talk about that later on. Hey, y'all, thank you for watching the show. Because Jerome got all wishy-wishy on me. Thank you for watching the show. We'll see you back next week.
My name is Dr. Michael Vincent. I'm here to discuss the true epidemic in the black church, which is diabetes and obesity.
Watch Rebalance Your Body Naturally with Dr. Michael Vincent